The only good idea is to let me and John do our job and mediate this thing right here.
You want to hear the crazy thing? I know it doesn't feel like it, but we're making progress.
Settle! Settle, 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 settle!
I don't want to settle.
All we're trying to say is, put your swords away for a second. Let's finish this and let's move on.
Welcome to Mediator in the Middle. This is your place to peek behind the curtain of what a mediator is really thinking. I'm your host, Abe Melamed, a litigator turned mediator. In this series, I, along with world-renowned mediators, will offer you, the clients, the lawyers, the parties to mediations, tips and tricks on how to be more effective in mediation and ultimately get yourself the best result possible. Thank you for listening. Please enjoy. Welcome back to Mediator in the Middle, a podcast about mediation, usually by mediators for lawyers. But in this case, today we've got some really special guests. So you're going to have by mediator and two lawyers. And we really have a great pleasure today of having both a plaintiff's lawyer and a defense lawyer who are pretty well renowned. Maria Bourn is a plaintiff's lawyer. Your offices are mostly up in San Francisco, are they?
San Francisco and San Jose.
Yeah. And I mean, you've been a super lawyer since 2016, named Woman in Law lawyer from Lawyer Monthly magazine. And I think maybe one of the most passionate advocates for plaintiffs in the state, if not even in the country. So we're really fortunate to have you to offer the plaintiff's perspective on this interesting dialogue. And we're going to try to peel back the curtain a little bit in both rooms on what goes into preparation for mediation and the parties' viewpoints, the lawyers' viewpoints, and maybe why it is that defense lawyers do this and why it is that plaintiffs' lawyers do that. So hopefully we'll get into some fun, interesting topics. Before I introduce Mike, Maria, anything I missed in your bio that you want to highlight?
No, I appreciate it. Thank you.
Okay, good. Well, appreciate you being here. And the second guest on the defense side is Mike Laurenson, who is the Gordon Reese, Northern California chair of the trial practice. Is that right, Mike?
Correct.
You've been a Daily Journal top employment lawyer a couple of times and have had verdicts reported in the top 10 verdicts in California defense verdicts. So a very skilled, very experienced litigator who also, I think, probably settles a good number of cases when they should be settled. So hopefully between the two of you, we've got some good perspective from both sides. Anything I missed in your bio, Mike, you want to highlight?
No, that was great. Thank you.
Okay, good. Well, thank you both for being here. I'm going to start with a question for you, Mike, and Maria, you can jump in if you've got any thoughts also. We'll go back and forth. One question that I think you hear a lot from plaintiffs' lawyers is, why is it that a plaintiff's lawyer is paying half the mediation fee? Why is that kind of the industry standard when you've got a poor plaintiff that has maybe lost their job, can't really afford it? You've got plaintiffs' lawyers that are fronting these costs, and the defendants could probably, they're in maybe a better financial position to pay the whole mediation fee. So from your perspective, Mike, why is it that you think it's important that the fees be split that way? Or do you think it's important that they be split that way?
I tend to not personally feel that it's important, but most of my clients do. So I try and accommodate my clients' desires in that regard. My clients tend to feel like it will make the plaintiff more likely to be invested in the process. I don't know if that's true. That's kind of their belief. And I think that, to the extent that there's any difficulty in payment, it's typically a temporary difficulty because most of these hopefully were successful in resolving them. And, oftentimes the fees are accounted for in that. So I'm not too worried about the aspect of it putting out a plaintiff who doesn't have the money to pay. I think that can typically be accommodated, but emotionally it's important to my clients, so I try and accommodate it.
Interesting. So I'm curious, Maria, from your view, I think one of the questions is, if 95% of your cases settle, that might be true, that it's a small pain point for a couple of months from when you pay to when the case settles. But if you have a lot of cases that just aren't settling, and I think we're going to talk a little bit about why that might be, maybe it is a bigger frustration. So what's your view on it, Maria?
I think it's a fallacy that plaintiffs are invested because the plaintiff isn't paying, because we're a contingency fee. So it's the plaintiff's attorney that's paying, and they have no concept of any cost, really. I know some plaintiffs firms have their clients' front costs, but we don't. so it doesn't matter. The only part that is on the frustrating element of it is that a lot of mediators now are getting up towards $25,000 of mediation. And, and that's a bit much to put out for a mediation, especially if that mediation is going to be in probably 6 months, a year, given that those mediators are the top mediators and they're so booked. But it really doesn't impact a plaintiff having skin on the game at all because they're not paying.
Right, meaning they're not the ones fronting that cost, so it might hurt the plaintiff's firm. If you're a solo practitioner with only a handful of cases, putting up $10,000-$15,000 as even half the mediation fee might be significant. If you're a bigger firm, maybe you can stomach it. But Mike, have you ever had that conversation with clients? Hey, look, plaintiff's lawyers on a contingency fee. I don't think it's going to matter to them. Let's just front it.
Yeah, I mean, I think Maria's comments are legitimate. I mostly hear it from institutional client, adjusters who do this for a living, and on that particular thing, they have their personal point of view that I'm not going to disabuse them of in my one interaction with them or a handful of interactions with them because it's their practice. So it's hard to change that when it's somebody's practice. But, I've agreed to different splits. I've agreed to splits other than 50-50. I've occasionally fronted the entire cost. It is really rare to pay the entire cost up front. I don't know that I've done that more than 5 times.
Do you have a concern, Mike, that in those situations, if you were to front it up front, since the standard is some sort of a split, it might signal weakness in that we are really desperate to try to get this case settled? Is that a concern you have?
I think my clients are concerned about that. As the attorney, I don't really think it sends that kind of message.
Let me ask you a question, Maria, because I know that this one burns in Mike's mind. Why do plaintiffs' lawyers start with outrageous opening demands that have nowhere near the value of settlement? And I don't know if this is saying that you do in particular, but I think that there are probably a number of reasons. I'm curious from your end, if your experience is you like to make really, really outrageously high demands to send a message, to play a specific role, or if you have any opinion about why maybe some other lawyers do it as well.
Well, I'd like to tie the opening demand to something, but it's hard when you're dealing with human suffering, right? And a lot of our damages are non-economic damages that relate to the damage to the human, and what that's worth is very difficult to evaluate. And it's difficult to come up with a number for that, even in front of a jury. And when in Vardire, one of the biggest issues in talking to the jurors is always, how do you value suffering, and can you do that? And they're always confused about it. And I think attorneys are equally confused because it's hard to put a number on it. But as to starting with the big numbers, it sometimes client driven, sometimes attorney driven. But I do always have a formula in mind for myself as to, okay, here's how I've justified coming up with this number. Attorney's fees are X, cost are X. These bad facts are this bad versus that bad. Come up with something
that you might be able to tie to a realistic number, which I think is helpful in the defense room. And I want to hear from you, Mike, also. But I guess to kind of just hone in on it for one more second, I think the real question is, why would a demand be made that's relative to what it settles for such a gigantic number? So in other words, if you're coming in and you're saying, my damages here might be $1 million, here's how I break down that exposure, that case settles for $300,000, $400,000, $500,000. I don't know that a defendant in that case is going to look at $1 million demand as outrageous. But if your case is going to settle for $300,000, $400,000, $500,000, and you come in with a $16 million demand, right? Which I think I've seen dozens of times as a mediator, but I wonder in those situations if it has more to do with sending a message, if it's often client driven, and maybe the caveat to the defense room is, this is client driven. Let's see if the mediator can work their magic. But what's your view on that? And I don't know if you do that ever in cases or if you've seen other plaintiffs' lawyers do that. But in those cases, do you think there's some value that you can communicate to the defense bar, if you will, of why that shouldn't terrify them and there's still a chance it can settle?
Well, I would hope if I was in the defense room and someone said $16 million and it wasn't at all a $16 million case, they would just laugh and come back and say, okay, $5,000, and then But my guess is if someone's saying $16 million, that must be client driven, because it's not typical that a case settles for $16 million unless somebody is assaulted and beat up and they're a long-term employee and have immense damages or some sort of stock investment that was worth gigantic values. But there are times that we have clients that, despite our recommendations, think that what happened to them is of substantial value that they will never get at trial. We can't convince them otherwise. And it takes a mediator to help with that. And that's why we select certain mediators. So it's like, okay, well, this client thinks their case will settle for whatever because they read some article about this person getting something. But I don't start in those kind of numbers. That being said, I'm sure numbers that I've started with, defense counsel thought I'm insane. But I have a reason, and I've come up with that reason, and I don't.
Sounds like you're more thoughtful. Yeah, you're more thoughtful than maybe many others are. And I call it internet verdict syndrome. That's the well, I saw Carney Shagarian did this. So Mike, how is it perceived in the defense room? Can you share a little bit about the way that plays out with your clients, with the lawyers?
Well, I think there's a lot going on in this question. There's a lot of aspects to talk about in this question. One thing that I was just thinking about as Maria was talking that might be hard on her side is you maybe don't know going in what your client would accept at the end of the day to settle the case. And that number might be a lot lower maybe than you thought or than you would have initially recommended, and in what happens that day causes it to settle for that. It's different in my room because I go in with a pretty good idea of what I'm gonna pay that day, and it's either gonna settle for within that or close to that, or not settle. Those are really kind of the only options for me. So what bothers me is the cases that settle for $50,000, $100,000, and we have to start out the day at $450, and at 4 o'clock it's still $250, and the case settles for $75. I don't know that process benefits anybody.
Sure. What I know when I was litigating, doing plaintiff's work, the reason why we would make demands that were really high, and it was always a goal to just make it as high as possible so that it didn't scare off the defendants from coming to the table, but was so high, was we wanted to capture as much value as possible. So sometimes we were shocked, and I can tell you this as a mediator, sometimes I am shocked by how much a defendant pays on a certain case. And so if you come in at $250,000, and there's a chance they might have paid $200 if you started at $600, but now they're not because it's relative to where you started, you might be leaving money on the table. So I've heard that from a lot of plaintiffs' lawyers. And then the other thing I've heard from a lot is that there is a psychological value in the defense room to feeling the victory of bringing that person down. So yeah, obviously, if you're going to pay $50,000, a $16 million demand is not getting you anywhere. But if you feel like you got someone down from $750,000 to $50,000 or in that range, you might actually pay 60 or 65 because that's a success, or So I think those are kind of the two key reasons I've been offered. And obviously there's the third factor, which I think is more common than maybe any of us are willing to admit, which is it truly is client driven, and we need the mediator's help there. But any thoughts on that? Why don't we start with you, Mike, on the way that maybe those values can be accounted for, but without it driving a wedge between the defendants and the plaintiffs?
I know. I think those two reasons that you gave are really good reasons. They're legitimate reasons for doing it. I like the idea of a demand and even an offer. I'm rarely asked to make. I always ask for a demand before agreeing because I don't want to waste 4 hours. I want to know, I want to be able to evaluate if I think the case is settleable based on the opening demand. I'm rarely asked for an opening offer. I'd often, I assume, be willing to do one. I don't know if it's ever been demanded of me. But I'm open to that. I'm open to doing more exploration I'm always going to assume that I can settle the case for like a fraction of the opening demand. And because 95% of them do, right? But there's a small percentage of them that don't, where the demand is genuine and the plaintiff's not going to move very far off those demands. Those are the cases that I always wish I knew a little more about before going to the mediation, because those tend to be really unproductive.
Sure. So I think there's two things I want to unpack from that. And I know, Maria, one of these is something that you've talked about. If I am providing an opening demand, why aren't you providing a counter, right? Why is it not industry standard to give some sort of a counter to get the ball rolling? And it sounds, Mike, like you're saying, well, ask for it, and I'm glad to give it to you. And maybe that's the solution. But what are your thoughts on that, Maria?
Yeah, equally with the other end of the spectrum, in the plaintiff's room where defense might think, oh, this opening demand is outrageous. A lot of the opening offers seem equally outrageous on our side, where you get an opening offer for less than the cost of the mediation or less than all the attorney's fees and time being there. And it's just like, wow, that's a huge waste of time. And it's defeating in our room, because even though I spend a lot of time preparing my clients for mediations, and I tell every client, ignore the first 3 rounds, because it's just nonsense.
Yeah.
And once we get past the 3rd round, then we start thinking about the numbers, and we do come up with a number for the mediation. And whether the client, I find that there's a percentage of that they'll go below maybe, but it's typically like maybe 15-20%, because we've spent a lot of time developing, like, why is this our number? Is this
Right.
reasonable? And not starting a huge number. But yeah, I like the bracketing, because it wastes a lot of time going back and forth with $3,000, $5 million, 5,000, 4.5 million, and then you're at lunch and you're gone nowhere.
What I've always wondered, Maria, is if if you're gonna start at 750 but settle the case for 75, do you talk through that with your client? Because my fear is always that by spending 4 hours with these ridiculous numbers, that we're reinforcing unhealthy expectations in the plaintiff that might make the case harder to settle. So do you have a discussion with them where you're like, look, I'm going to start at 750, but you're not getting 750. You're not actually even going to get 500. We're going to try and get, 100 to 200, and that's what we're going to try and do. But we're going to, do you talk through the numbers that much with them?
Well, it's more of a reverse process. Okay, what's the case worth? What should we settle the case for? And then we come up with the starting number based on that. And probably if you put enough defense attorneys in a room together, they could come up with my formula for coming up with my starting number, because it's based on where I want to end. And that's, sometimes a plaintiff, so you come up with that number beforehand and you come up with the starting number, but for some reason they're like, you know what, I'm really just done. In fact, I'll take something, and you advise against it. Like, I don't know, no, we can just give it time. No, I'm done. That's pretty rare, but maybe that is where some people get to the 75, but I would never recommend starting at 750 and taking 75. That's kind of ridiculous.
But what you are recommending is part of the discussion.
Absolutely. But it's backwards. Like, where do we want to end? Why do we want to end there? Does that make sense? Is that reasonable? We put an Excel sheet with jury verdicts. Is your expectations reasonable? And they're outliers. Of course, there's somebody that's got this, but that's an outlier, and somebody's got a defense verdict. That's an outlier. Where is it in the middle? And, are we in those numbers in that range? And then come up with the starting number. So the starting number is, for me, always based on where I want to end, not some magical wish.
Yeah.
I mean, I do something similar in my room, in that I'm just negotiating to my number. I largely let the mediator worry about what's going on with the numbers in the other room. I don't, in other words, the numbers are either going to come down and meet mine or come close to mine and we're going to settle, or they're not. But I kind of negotiate to my number, and I let you guys and the mediator do whatever you're doing in your room. And in a perfect world, you have two competent attorneys and the numbers are close enough together that the case settles. And in an imperfect world, it doesn't. But I don't so much care about where you start or what your next move is or what your move after that is, because I'm just going to my number.
Well, let me ask a question about that, Mike. So I understand how in your room you're going to perceive the plaintiff's numbers, but how are you handling your numbers? You have, let's say, $100,000 in authority, and your first response is $5,000. Okay, that's in response to the outrageously high number, but are you feeding that $100,000 in relation to them? Are you doing it as a percentage of what you have, or do you have a fear about, are you ever worried about this, what I think is a misnomer that, oh, I'm going to compromise my settlement position if I put all my authority on the table? Or do you kind of say to the mediator, here's what I have, lay it out how you want?
Well, I mean, my preference is always to start at a reasonable number. I would prefer not to put $5,000 on the table. And I think we only do that in response to the silly opening demands. Typically, I'm going to try and put a reasonable number on the table that's going to give me enough room to get to where I need to get to, on the assumption that the case is going to settle for, 25 to 50% of what the opening number is. And so I got to give myself room to get there, because I know it's got to come down that far. So it's going to take a while to come down that far. So I just have to give myself enough runway to operate in. But I mean, I would prefer to start at a reasonable number and go to my number. Work
from there. Yeah, I always tell parties the first person to be brave in the negotiation controls it. And so just ignore the opening number and give me a real response, as if it was you're being asked to offer the first number. But I know that's sometimes hard, especially with clients when they're really passionate about it. And well, that's an outrageous demand, so we need to respond in kind.
Yeah, I mean, I settle a lot of cases without mediators, by direct negotiation, and I do that by not like lowballing people. Like if I'm going to have a direct negotiation with somebody, I try and start at a reasonable number that's pretty close to where the case should settle. And yeah. I would prefer to do that at a mediation too.
Yeah, and it sounds like then you're taking some multiple of, or reducing the number, the opening demand by some multiple, whether it's 25 or 50% of that number, and assuming that's what the plaintiff wants, and saying in advance, well, would I pay that if I would, or I'd pay something close? Let's mediate. If not, nothing to talk about. But that's what leads to the frustration when an opening demand is $1 million, and you're assuming that means somewhere between $250 and $500, but it turns out plaintiff's counsel actually means $1 million or $950,000. Is that the frustration you were describing before?
Yeah, which doesn't happen very often. But I mean, there is that circumstance where people's opening numbers are genuine, and they really want that much money, and you're often not prepared for that. You know, because again, you assume because 98% of your cases settle for between 25 and 50% of the opening demand. That's what you're assuming is going to happen. And so if you have, this is obviously a rare circumstance, so I guess it's not that big a deal, but if you have one of those cases that's not going to settle for 25 to 50% of the opening demand, I think you should make sure the defense understands that before you go to mediation, or they're not going to come with enough money, right? Sure.
Actually, I think that's a great question for you, Maria. How would you like to see it be the most productive mediation? I mean, would you rather see that you're both exchanging a bracket in advance? Do you want to hear a reasonable counter first before saying yes to mediation? What do you think is the most productive way in your room, Maria, to make sure that that's communicated what you really mean? Do I mean 25 to 50%, or, maybe you would say 30 to 60% of my demand, or do I mean I want 90 to 95% of my demand? How do you think it's most productive to make sure that message is communicated?
Yeah, I think a bracket's helpful because it at least eliminates some dance moves within the process. With the just saying my number, with the plaintiff side, I try to send out 998s because we get interest if we win. I don't see any reason why you wouldn't send a 998 as a plaintiff's counsel. And what I get a lot of times, there's often that I'll negotiate for the 998, but sometimes that's really the number. And that I sent the 998 because I thought this is the number. These are our attorney's fees right at this point in time. These are the damages. This is the number. And then you go to mediation and they're trying to negotiate from the 998 that was 2 years ago. No, that was the number 2 years ago based on the attorney's fees and the damages pre all these depositions and pre all of this work and these costs. So maybe those conversations would be really helpful, specifically if there are 998s out there to say, okay, well, we have this 998, we're not negotiating from that number, so don't expect it. And if you come in and try to negotiate from it, it's going to be pretty quickly a failed mediation, specifically if it's a 998 set, a year or two further.
A while back. Mike, any thoughts on that? I think those are great points, Maria.
I mean, I've had 2 experiences with plaintiff 998s generally. One is, they've been made in a couple cases that didn't settle. They were kind of Maria's kind of genuine 998s in cases that didn't settle and went to trial, or the case ended up settling for a fraction of the 998. So I'm still in that situation where if it's a real 998, I just want to know it.
You want to know the actual number, meaning not an inflated number.
If this is one of Maria's situations where she's like, this is the real number, I just, you want to know that, because I've had so many plaintiff 998s where, again, that case is ultimately settled for a fraction of that. So it wasn't the real number. But there's some that are, and most of those that are have ended up going to trial. Those are kind of few and far between,
Sure. Yeah, I think the 998 piece, I'm writing an article about it right now. If either of you have some examples, feel free to send them along. But I think that too often plaintiffs discount the defendant's 998 as either not ripe or too low, and they just say, I'm not going to ignore this. And on the flip side, defendants often offer 998s that are, just far too low or at a stage when the case isn't ripe. So I'm gathering examples of where a plaintiff rejected a 998 they should have really strongly considered, and it came back to bite them. And in the reverse, where a defendant made a 998 that was just not ripe or too low. So I think it's an interesting issue, but that maybe that's something that you can both do. Both sides can send a 998 in advance of the mediation, and that sets your parameter for the negotiation. But I think then you have that problem, Mike, you just described, which is if that's not actually truly your number, don't put it in the 998, right?
Yeah.
And maybe
I love
also
998s. I love 998s. Yeah, I
like them.
I try and serve them early. I try and do them plus fees, and I settle a lot of cases with 998s.
Yeah,
and I've settled a lot of cases following failed mediations with 998s.
Yeah,
where we have not settled, and the plaintiff has staked out a number that's too far away, and that's all they're gonna take. And then I've done a 998 following the mediation that's settled the case down closer to my number, because when you do a plus fees 998, it makes things get real in a hurry.
Maria, do you appreciate those 998s after mediation?
Yeah. Oh yeah. I like 998s because on the plaintiff side, we have to come up with a number that we think we can beat. And so it's a number based on reality, not just somebody's unreasonable expectations. So I like them. I think they're very helpful.
Do you find, because of what you just said, do you find that it's more helpful if Mike makes a 998 inclusive of fees that's at a higher number, so you really know what you're trying the case against? Or do you see the value in the 998 exclusive of fees, because then you can go make your application and get what you deserve.
It depends on the status of the litigation and where the damages are. So if you have a low damages case, but you've really just worked it up because maybe you love this client and maybe it's a cause that you really care about, so you've just put a ton of effort into it, even though ultimately the damages are pretty minimal. That's hard, because if you have a 998 exclusive of fees, it might make sense to settle, but it ultimately benefits the attorney more, right? And that's not necessarily always fair or right.
Right. Depending on how you've got retainers structured, but we won't get into that. Yeah, fair enough. Well, let me ask you both this question, and I'll start with you, Maria. But what about the mediator's role in mediation do you want to know in the defense room? Meaning, are there questions or things you want to know about the way that a mediator is most effective in the defense room, or what you might be able to arm the mediator with to make the biggest difference in the defense room? Why don't you share your thoughts on that with Mike, and I'll let Mike respond, and then we'll reverse roles. How does that sound?
Gosh, that's a hard question. Because I only can see it from the plaintiff's room, where you come in and, oh, this is what's wrong with your case, and kind of beating up on the witness isn't going to be good, or the plaintiff's got all this baggage. And so maybe the question is, is that happening in the defense room? Are they getting beat up? And, or sometimes I get the impression that they're just in there jumping it up, talking about their vacation and making it seem like something's happening.
And like they're beating up.
Our room to talk about, oh, well, you better settle your case because I've never seen a verdict as much as you want, but I don't know.
I think that's a great question. Mike, am I really beating up on you in the other room?
No, the reality of the situation is Maria's most of the time we're chumming it up.
That's what I figured.
Yeah, no, so I mean, I like to think that I know how to evaluate a case, that I'm pretty good by now at figuring out what it's worth, and a majority of the time, the mediators that I work with are going to kind of agree with me. We're not going to be at outrageous polls. I mean, we're typically close, if not overlapping, in kind of what we think the value of the case is. And there's some time in the beginning where I'm getting beat up about, my weak facts. That always occurs in every mediation. In a visit or two, but by the third visit, it kind of becomes us working together to figure out how to get you guys to our number.
Fair enough. I'll offer some thoughts on that too. But Maria, what's happening in the plaintiff's room?
Oh,
I'd love to know. Is it tougher in there?
Are we just summing it up?
It is, and it depends a lot on the mediator. And also, some of our clients have sensitivities to certain things. And if a mediator is attacking them on those issues, such as if you have a transgender client or a non-binary client or a person of color or a person that's been sexually assaulted, and they're going after like, well, why did you text that person after you were sexually assaulted? That's going to look horrible. And it's like, that's just not helpful in the mediations, because you're opening a big wound that is difficult to overcome in the mediation. So then it keeps coming back to it and back to it and back to it. And then you have a client that is emotionally distant and not really psychologically ready to settle their case because they're angry.
Yeah. One of the last cases I litigated, I was doing plaintiff's work at the time, was a rape case. And I had a client who was there weeping, telling her story. And the mediator, who was terrible, sat across the table, which is the first mistake. You sit down next to that person, and started yelling at her, like, if you can't even sit through this, how are you going to sit through trial? And just lost all credibility, and it drove a wedge. And that, I don't think any mediator should be doing that, certainly not in the plaintiff's room. But I do think that what I can say from the mediator's perspective is, I am beating up on both sides in my own flavor of a way, and different mediators have different flavors. Mine is more collaborative and more, let's talk about, think about this issue and how do we overcome this problem and what do we think about this? But absolutely, I'm making sure both sides have evaluated that risk. I think there's always a value in that neutral third-party view, but I actually want to hear both of your thoughts on what, Mike, you were saying before, which is I do think that in the defense room, you're being a lot more calculated. So it is often the case, and I always ask this question in advance, but it is often the case that you're saying to me as the mediator, I have a really tough client. They're not seeing why they should take my recommendation, but I've been trying cases for 30 years. I know how to value a case. I would recommend X. They don't see that value. I need your help. Or we both need your help, me and the client, with the carrier, because the carrier is not paying what this should settle for. But you're being much more thoughtful, I think, and there's nothing I can say as the mediator that's going to blow you away from your number. Maybe I squeeze 10% more. Maybe if it's a really significant development, I squeeze 25% more on a mediator's proposal, but that's never changing in a massive way generally. Whereas in the plaintiff's room, I do think that there's a lot of factors at play. You are absolutely right, Maria. Sometimes you're not recommending it to the client, but the client wants to settle it. And you're saying, I'll get on my hands and knees and beg you not to take this little money, but that's what they want to do. Or sometimes you're learning facts for the first time in the mediation process that have to change your valuation. And sometimes it's not until there's real money on the table that you can consider it. So I think that it is a little bit of a different calculus in each room what the role of the mediator is. But I'm curious if either of you wonder more beyond what you've expressed about the role of the mediator in the other room.
No, I mean, I don't wonder. I've always felt that it's really hard in the other room. I'm certain of it. I'm certain it's really hard in the other room. I think I mean, you're doing a lot of work in the other room. I know. And so I don't, and most of the times you share with me how hard the work is and what's going on there. And so, I mean, I appreciate it, but I try to come to mediations with a coherent team that's all on the same page. And, if there are these disputes that you're talking about with carriers and insureds, that I try and work those things out ahead of time. And so those are hopefully few and far between, and we're kind of on the same page and we have a goal. And hopefully if that goal is reasonable, we enlist you to help us reach that goal. That's typically what mediations are for me. I don't spend a lot of time getting beat up at mediations.
Yeah. Well, maybe you're a tougher cookie and you don't need the beating as much. And I'm kidding. I mean, Maria, in your room, does it feel that way with a lot of mediators, like they're beating up, or do you think that many of them are really just trying to be thoughtful and evaluative, but then let you kind of drive the bus on what you want to settle for?
Well, I think the difference is when you're in the plaintiff's room, you're dealing with the person that something has happened to, right?
Yeah.
Whether it be a car accident, a termination, some kind of injury. Or if you're in the defense room, you're dealing with a corporation that's making a business decision. And those are very different people in different spaces to deal with things. And so it is different in the plaintiff's room because I'm dealing with somebody who is emotional because given, maybe they've broken their arm, lost their spleen, have a traumatic brain injury, have been fired from a 30-year job, whatever it is, that it's them that's sitting right there. And it's them figuring out, well, what is the value of these damages to me? And that's hard. And it's hard to listen to contrary beliefs. A lot of people have confirmation bias, and specifically the person that this has happened to has a lot of confirmation bias. And when your mediators coming in and saying, well, a jury might not like you,
yeah,
certainly difficult to overturn the flavor of that mediation.
Sure. Now you gotta, I hope most mediators aren't coming in and saying that. I think it's, I like you, but how do we think a jury might perceive X,
I find judges to be a little bit less sensitive to those issues. I've tried, you hear, I've had 600 employment cases in front of me, and I can tell you what a jury is going to do when they hear you talk. And that's very difficult. And I think a more trained mediator on sensitivities to certain issues is helpful versus a judge who might not make those considerations.
Yeah, a lot of times they feel like they're still wearing the robe. And I know some amazing mediators who are former judges, including many of the founders of Signature Resolution, but I think they do get often stuck in, I'm wearing a robe, I'm going to tell you what, when client might need a catharsis. And I think it's an interesting point you made before about your different clients' roles, but oftentimes in the defense room, it's a business-minded, pragmatic person, but many times it's not. Many times in the defense room, there's also catharsis. You might have the CEO, the COO, the harasser who is involved, or the alleged harasser, and they need to tell their story too. You might have an insurance adjuster whose bonus is tied to the outcome, or, So, I mean, Mike, in your room, would you say percentage-wise, it's 25% of the time that there's a catharsis element? Do you think it's less, more?
I mean, I do often have people in my room who are accused of discrimination or harassment, and that's a tough thing for them professionally. So there is, there is a percentage of the time where there's some significant emotion in my room, but it's a fraction of what you guys deal with in the other room.
Fair enough. Well, let me shift the conversation for a second into maybe the last topic I want to highlight, because you've both been so gracious with your time, and that is the information exchange between both sides. What really does make a difference in each room? And as a mediator, I'm a huge believer in as much front loading of the process as possible. I did an episode of the podcast with Lee J. Berman focused solely on that. And I find a lot of what I'm doing these days is task mastering both sides. Get me that witness statement. You're claiming poverty, give me your documents in advance. But I think why don't we start with the questions that the plaintiffs might have in the defense room, and I'll go through a couple of these, but Maria, feel free to fill in any others. Does it make a difference in the defense room if you get a victim impact statement on a video, let's say, of a plaintiff describing how it's affected them? Does it make a difference if you get therapy records in advance and, or treatment, not just treatment, but expert reports? Or is that kind of something you check off a box in your actuarial table, but it doesn't matter as much? How are you assessing these witness statements that pop up for mediation purposes? I know I'm throwing a bunch of things at you, but I think that's the question I would have from the plaintiff's room is, what does make a difference to you that as a plaintiff's lawyer, someone like Maria can try to gather in advance to help at least demonstrate the value of their case?
So I think smart plaintiffs' attorneys know that the surprises are not good.
Yeah.
At a mediation. I mean, I'm dealing with people who are making business decisions that they have to get approvals for ahead of time, and we're operating within a zone of tolerance around that approval, and we're not going to come to a mediation and settle a different case than we came to settle. It's not going to happen. It's not going to settle that day. And so that would be a failure. And so if you have helpful information, you should share it. I never understand they have 3 witness statements that I'm not allowed to show you. They've shown me. I mean, that doesn't work. That doesn't work with me. So first of all, I've seen enough witness statements that are just completely filled with inadmissible hearsay that I need to evaluate it for myself with my own eyes. And so, we have 3 witness statements that they're not going to show you. It's not helpful. So I never understand that. I don't understand the holding back information at mediation. I would think you always want to kind of put your cards on the table. And if you got something helpful, and it might settle the case, that you put it on. I don't know that I've heard people say it before, but I don't know if I've ever in my career been in a mediation and said, we got this great nugget, but don't tell them. I mean, what? Aren't we there to settle? What am I holding nuggets back for if my purpose is to come there and settle? I never understood that. So if you have helpful evidence, I want to see it, and I need to see it with my own eyes.
Fair enough. And Maria, before I kind of turn it on you, any thoughts on that piece? Are there times where you're intentionally not sharing certain pieces of evidence? Do you have certain concerns that you think are worth expressing?
Well, We have a private investigator that works for us, and she's getting witness statements as much as we can early and often. But getting witness statements signed is a whole different can of worms, because we've got the person to talk, we've recorded the conversation, but then getting them to sign a declaration and finding where they're at, and it is more difficult. And so we might have a witness statement or information that we have, but are we just going to turn over an interview? Probably not. We'll say, look, we've talked to these people, here's this information. They might say, oh, give me this statement. And you know, I'm not going to do it at this point in time. And a lot of the problem is that maybe we've talked to current employees or past employees or people that are afraid that they too will be retaliated against for some reason, and or people that don't want to be dragged into the litigation, but they're willing to just talk to us. So we're dealing with that element that makes it a little bit difficult.
Yeah. And I will say, you know, the other concern I hear a lot from both sides is if we share this information, we know there's mediation confidentiality. You can't use it, but we're worried that this is going to somehow change this case. And I saw cases as a litigator where, you know, we confronted someone with a question, and then in their deposition, suddenly, miraculously, their testimony was different from what they'd said in the mediation. So I think there is this kind of inherent struggle. I teach a negotiation in some law schools, and it's the negotiator's dilemma is the term that's used, which is the more information you share with both sides, the more opportunity there is to expand the pie and to really fully evaluate things. But there's also this inherent concern that puts you in a weaker position for the other side to use it against you. So I guess
my thought is, what percentage of helpful information could you have in your room that I'm not going to find out about if the case doesn't settle and goes forward? Man,
Sure.
Aren't I going to find out about it eventually?
Yeah. I think
if it's relevant, if it's relevant and helpful, aren't I going to get it eventually? I mean, the percentage of information that I might not get is really tiny. And so that's always been my view. I mean, we have witness statements, but we're not going to turn them over. Well, I'm just going to send discovery. I'm going to get names. I'm going to talk to, I'm going to find out all this stuff eventually. And we're trying to settle today. So why aren't we, let's do it now. Let's talk about it now.
Yeah, I'm a big proponent. Maria, any thoughts on that?
I mean, I agree if we can, but if we don't have a signed declaration, what is that?
Agree. I understand the work product thing. I get that. Yeah.
But and also if we're dealing with people that are really scared that like, look, ultimately I will talk if I'm subpoenaed or whatever. It's like, okay, well, at least we had the opportunity to get some information and to understand what they might say at a deposition. I've been surprised when people will say something totally different.
The about face.
But yeah, it's really for us more to protect the people that are willing to come forward and talk about things that are afraid, and trying to protect their whatever
anonymity,
make them afraid.
Right, their privacy or anonymity. And I'm actually curious, Mike, on your end, if it's not a signed sworn declaration, does that still have value? Because I often will encourage parties in advanced mediation, just get an email from them, get something from them in writing. Is that valuable to you?
Yeah, it would absolutely still be valuable. I'm going to look at the quality of the evidence, not the format that it's in. Yeah,
and that frankly might even in some ways be better for you, Maria, in the plaintiff's room if you don't want to lock yourself in per se, but you want to make sure to communicate the core of it. Sometimes it's better to lock yourself in. Well, let me reverse it for a second and just say, Maria, are there things that you wish you got more from the defense side that, and again, this isn't just Mike per se, it's defense attorneys, but things that you think would be really helpful for you to evaluate in advance that you wish you saw more of?
For the most part, defendants control all the information, right? Because it's an employer in an employment case for us, and they have access to the witnesses, to interview the witnesses if they're current employees, and have access to all the documents. Where if it's an early mediation, we don't have access to that, because a lot of people really don't want to talk to us unless they themselves might be angry or they're not working any longer. But if they're current employees, most likely they're uncomfortable coming forward and agreeing or disagreeing with whatever it is that happened. And so if there's bad information that's out there, such as, oh, your clients, we have video of your client clocking in late every day, but putting on her time card that she arrived on time. Well, why wouldn't you tell me that in advance? We're contingency fee. If there are bad facts, let us know so we can get rid of the case, or we can settle the case for a different value. We don't want to work a case up that I don't, maybe other attorneys are okay with it, but that has bad facts or whatever. So if they're bad facts based on interviews of witnesses or documents, I would want to know that. I want to know it early. You know, hey,
As early as possible.
yeah. Did you know your clients stole something or whatever it is? Versus, I'm going to surprise you at their deposition. Why would you do that? It doesn't make sense.
I agree.
Yeah, I mean, it sounds to me like both of you are on the same page about the information exchange. You're both kind of saying, why would you withhold that? This is your chance to persuade me to settle this for less. And, you know, on the flip side, just pay more.
Well, I mean, in a perfect world, you'd have two competent attorneys exchanging information and coming to an informed opinion on the value of the case. And hopefully it's close enough or there's some overlap and the case should settle. And the only cases that should go to trial are the ones that, despite that process, you just can't agree on what it's worth. But there should be a full and open exchange of information, and you reach a consensus about what it's worth, and it settles, and they should all settle. Or you can't. You just have, for some reason, you have this disagreement about the value of the case that happens sometimes, and those are the ones that don't settle and go to trial. But all the other ones,
they should settle.
You should turn over everything and make an informed decision about what it's worth, and with the mediator's help, and settle it.
Yeah. Well, I can say that's the way that I approach it. And I tell people I don't like the mediators that use the phrase a good settlement is when both sides leave unhappy. I actually think it's when you feel confident and happy in having made the most educated decision for yourself. So my role as the mediator is to make sure we turn over every stone. We think about this from every angle. We make an informed decision. But in both rooms, you're competent to make that decision. And you're right. It's either we just can't agree, or we've got a crazy client that, you know, wants to try this case despite us recommending it should settle it, you know. But I think it sounds like the two of you are on the same page about that information exchange, which I think is so critical. And I think there's, you know, I think if you can do this between the lawyers and you don't need a mediator, by all means, you shouldn't have to pay these outrageous rates. But there's a value, I think, of being able to exchange it within the mediation confidentiality and also the editorialization that comes with it often, which is let the mediator, you know, oftentimes it's let me ask the client the question, see how they react, and then let's confront them with this piece of information. And I'm curious from the both of you, and then we'll kind of end on that topic, is do you find it's valuable to do that so long as, and this is the key caveat, the mediator or the, you know, counsel makes clear to the lawyer in advance what they have? Meaning what I would prefer to see is, let me show the lawyer that you've got all these negative witness statements, you know, about the plaintiff's performance. Let me show the lawyers, you know, the statements you have on the plaintiff side that corroborate it. So everyone understands what the evidence is and can evaluate it. But maybe we should spend the day with the mediator playing that role to kind of on both sides feel out what, you know, the way the client's going to respond to things and socialize people the way that evidence might affect people. What's your view, both of you? Why don't I start with you, Maria, and then we'll go to Mike.
You know, like Mike, it's helpful to have that information in advance of the mediation because we spend time working with our clients, evaluating the case, coming up with a number. And if it's out of the mediation, it's really hard to switch gears into, okay. You know, and those mediations just don't settle because it takes time to re-gear. And also, given that I'm dealing with a person, if some surprise is like, well, you're a thief.
Yeah.
Now that person feels very offended and angry. They're not going to be ready and willing to settle a case. They're going to be ready to leave and be even more angry and think that they want to double down and get more money because now they've been called a thief or something. I don't know.
I think that's a great point. And Mike, I imagine in your room, it's even more so that if you've got a, you know, don't come in and say, my client testifies to X, but there's no evidence. And then suddenly we show up and you've got a video of the sexual harassment or something because I can't settle that case.
Right. You know, what I was going to say, something we haven't talked about yet, so it's a little late to bring it up. But I mean, I exchange briefs in every mediation, even if the other side's not going to give me theirs. I'm going to give you mine, and that's my case. I mean, I put in my brief what my I've never held back the golden nugget. I'm not the silver bullet. I mean, what I'm putting in my brief is my case, and I've given it to you ahead of time, and it's not going to be that different at the mediation.
Yeah.
The only thing the only time when I come up with new evidence at a mediation is in response to an argument from the other room about, an event that I wasn't aware of, that we haven't considered, that I don't have evidence of, and we have to go during the mediation and do some investigation and see if we can find the document or confirm a fact or something. But I mean, generally speaking, I'm giving you my brief, and the case I'm mediating is the case I've told you about in my brief.
I think it's a great point, and I still have time on the clock if you're both willing to, but I'm curious,
Sure,
Maria.
sure.
Maria, how do you feel about that? Are you one to exchange briefs if both sides agree?
Always 100%, because I understand that if I want to get the value of a case that I think it's worth, then I need to present the facts, right? And I need to have evidence that supports it, including medical records, declarations, therapy records, whatever it exists to prove up the case. In some cases, we have expert reports prior to the mediation. And that's of help, because then they can analyze the economic damages as well. We have all that stuff in advance that we've given them to make the decision, and they look at that and say, well, we're not prepared to come anywhere near what you have, then I would appreciate knowing that. But what happens on our side is I'll say, here's our brief, here's our opening demand, and it could be, say $1, and they have 10 cents. I would appreciate a response. We're never going to get to $1 or even half of $1. So let's not continue with this mediation. But 90% of defense attorneys, and I'm just making up that number, do not exchange their briefs. And I have no clue why.
I can't believe that. Really?
Most defense attorneys do. They say it's their practice. They don't. It's their client. I've heard a million reasons, and I think
that's
why not
crazy to me.
Give me the tools to convince my client that their case isn't worth $1. It's worth 10 cents. Just as I want to give you the tools to convince your client.
I'm highly suspicious when someone won't give me a brief. I'm like, how do you expect to persuade me if you're not even willing to share your brief? I mean, have you even worked up the case?
Yeah.
I mean,
a lot of times the answer is no.
Yeah.
Many times the answer to that's no. But I completely agree that I think it's more often than not that the defendants are not willing to share it. And I think in some respects that's maybe bred the plaintiff's bar to have the same perspective. So it's rare that I get people that are willing to share the briefs. What I strongly encourage is to share.
I've never even filed a confidential brief with the mediator. Again, the thing I'm briefing and handing around to everybody is my case. I'm sharing. Yeah,
it's
sharing the same thing with everybody. And I've at least 50 times I've asked about exchanging briefs, and the other side has said, no, we don't want to do that. And I've said, well, I'm sending you mine anyway.
I'm sending it anyway. I'm a big advocate for that. I've said that before. And, I've said that to plaintiffs' lawyers too. Like, listen, they may not give it to you, but if you've got great evidence, they need to run it up the flagpole. So make sure that you get, but yeah, I mean, look, I think what the biggest takeaway for me is that the two of you, I think, are doing it right. I wish I would see more lawyers on both sides doing that, which is give as much information in advance as possible. And by the way, do it as early as possible, because I'll tell you something, as a mediator, it is very frustrating. I'm the type, I have pre-mediation calls in every case, and I push both sides in those calls for their numbers. What is the real range this can settle in? And if I hear from plaintiffs' counsel, we will not take a penny less than $1 million. And I believe that's 25% within the range of where they are. And I hear from defense counsel pretty convincingly, this is not a 6-figure case. I really want to say, let's just cancel this mediation. What's the purpose? And sometimes I do. And then the response sometimes is very telling, like, oh, no, let's still do it. But if we're not doing that till 2 days before the mediation and a pre-mediation phone call after I've read all the briefs, and, I would much prefer that both sides have exchanged as much information as possible and maybe even some numbers to make it clear this is going to be productive, because otherwise you just paid me how much money to come in and find out an hour in that there's no world in which this can settle. So I like the way you both have, I'd like to see more people adopt it. Let's put it that way.
Well, you're certainly gonna improve your chances of resolution if everybody's showing their cards.
I don't know, Mike, if you have this problem on your end, but sometimes one of the associates will be like, "Oh, we got this mediation," and then okay, where's the brief? And then I'm reviewing the brief, and I look and I see the mediations next week, and they're getting to me a few days before the mediation, and I think, geez, that's not helpful. Where are these medical records? Where are the have you talked to the person's husband? Have you, we have a PI person, you don't even have to do it. Just have them go call these people. But it's getting to be so late that, okay, now maybe we get all of it put together, but it's the day before the mediation. How helpful is that?
I mean, sometimes there's the reality of life that, the case isn't adequately worked up. For the mediation.
Yes, that's a frequent, it's not so frequent, but I see it a lot. That's why I want briefs at least a week before, and I want to have a pre-mediation call the next day. I'll read that brief on the spot. You can send me hundreds of pages, I'll get through them, and then I'm going to say to both sides, give me this, give me this, give me this. Why don't you have that? Why don't you have this? Because I think that's some of the biggest value a mediator can offer. So I'm glad that both of you at least appreciate that process. I think that's a perfect spot to say thank you to both of you. And I really, truly appreciate you both taking the time. Non-billable time, I should say. So thank you, Mike. Thank you, Maria. I really appreciate it. Without an audience, we would be nothing. So I'd like to thank you, the listener, for tuning in to another episode of Mediator in the Middle. Please take the time to subscribe on your favorite podcast platform, Spotify, Apple, whatever it might be. And please feel free to refer a friend. Until next time, we look forward to seeing you, and keep calm and mediate on. Thank you.